Okay, my lord, item number list, my lord, 54, my lord, appearing, my lord. In this case, my lord, although my lord, there the initial stay at the time of admission of appeal, my second appeal, my lord. And there is my lord, interim order till April. And till end of April, my lord, my lord, before expiry, I filed an also application for extension, my lord. But the all these things were stated to the trial court, my lord, but trial court, my lord, not considering but continuing the execution proceeding, my lord. For this, I already mentioned my matter already listed. I also mentioned my other side, my lord, fingerprint is there, my lord. Can you fix next week any day, my lord? Otherwise, my lord.
Where is the notice?
Notice given, my lord. Given. Notice of.
We're appearing.
Trial court, my lord. Kindly see, my lord, trial court not considering the High Court initially granted stay, my lord.
See, putting your matter, you will come and ask for adjourn. Because you have become an adjournment counsel.
No, my lord.
Yesterday also.
No, that today, my lord, I prepared, my lord, I will.
I gave you 3 examples. You could not.
No, my lord.
One matter,
Yesterday,
second matter,
my lord,
first matter,
yesterday-
second matter, third matter.
My lord,
Yesterday it was the 4th matter.
my lord, yesterday I asked, my lord, today I will complete my submission, my lord.
Not ready, my lord. That's my lord.
Today it's.
Back, my lord. I
No, he is not saying that এটা কত নম্বরে আছে?
54, my lord.
Be there. If I am able to take it up, I will take it up.
Kindly fix otherwise, my lord.
No fixing. I do not fix matter.
Kindly see the order that will be under trial.
I will not fix the matter. It is in the list. You have mentioned it. I have taken note of it.
Any further mentioning? Item number 1, under arbitration. My lord, item number 1, praying for a short pause because conducting advocates code number 4 appearing in another matter.
প্রথম মামলায় অ্যাডজার্ন মানে পাস ওভার, তখন আজকে আর কিছুই হবে না। ঠিক আছে, চলো পাস ওভার। I will come back within 5 minutes. I will come back to this matter within 5 minutes. Room number 4 bail application is going on. It will not last for much. Yes, call with the expert.
Item number 2.
I'm seeking for short pass over. So Mr. Mojumdar will appear, please.
আর কি করা যাবে? চল দেখা যাক।
Item number 3, under civil motion. Item number 3. Item number 4.
Oh, my lord, I am appealing for the opposite party husband. My lord, in the earlier occasion, your lordship had the matter, my lord, regarding the domestic violence. My lord, my point was that it is not maintainable since under section 28 civil.
Where is your other side? He
But I have brought all the documents relating to payment to the wife. Your lordship, in the earlier occasion, please.
who is appearing? Who is appearing?
So, who was that?
Ask him to be present in the second call. Let me look into it.
My lord, till date 20,67,000 has been paid, lodge.
Item number 4.
I'm just supposed. Lord, there is a dues of close to 9 lakhs something.
First, you satisfy that your revisional application is
Yes.
maintainable.
My lord, sir, there is a full court judgment of the Madras High Court, which says that this section 12, being civil in nature, my lords, the only way how it can be challenged. Can you give me a short password of the judgment has gone to be photocopied to us?
Very good. Very well, passed over.
Lords.
ডাকতে থাকো, ডাকতে থাকো।
Item number 5.
Lordship, I beg to appear on behalf of the respondent number 1 to 5 in this matter. Item number 5.
Who is for the petitioner? Item number 5, who is possible for?
Item number 6. My lord, I.
Great Lordship.
Yes?
My lord, the case relate guardianship and award.
No, very well.
My lord, the petitioner.
I will, is it appearing for the first time or it has been served? Served. Who is appearing?
No, my lord. No, first time, my lord. First time. It is first time I serve. My lord, one order, the dated power.
Who are you? You are the father or the?
My lord, father was died.
Hmm.
Father was died in this.
Father had died, was no? Father had died.
Father died. His landed property will devolve to petitioner and to minor side. My lord,
I could not get you. Guardians and Wards Act. What is the issue involved? Who has made this application?
Application, my lord, only for the permission. Sale.
Who has made this application?
Mother, my lord, mother. Minor's mother,
Minor's mother.
my lord.
Minor's mother has made an application.
Application.
For?
He unable to pay the educational fees of the minor. That is why the petitioner pay for sell the minor's property. Only.
See, the difficulty is that in these matters I am very clear on my view. What is the age of the mother?
My lord, mother is 40, my lord.
40. 40.
40 above. My lord.
When did the husband die?
Husband died, my lord. Dead, my lord. 2022, my lord.
Aged 37 years. See, let us take it, don't think you are briefed in this matter as an advocate. Think you are an officer of the court. Today, you cannot rule out the mother may remarry.
Oh, my lord.
You can give you can give assurance on behalf of your client that she will not marry. Now, if she marries, what will happen to the minors? Because the property, the share of the property is the security of the minor. Because they have their entire life. What is the age of the minor?
My lord, one is class 10, reading class 10,
Yes.
and another is 6. Class 6. My lord.
So entire education cost is there. Now you want to sell off one of the properties, one or all the properties.
No, my lord, only.
What is the extent of property? What is the value of the property?
But my lord, it will be only 10 lakh.
Only 10 lakh.
Only 10 lakh.
Where have you stated so?
My lord, the main petition I have stated in the court.
Have you not annexed that petition?
No, my lord.
You bring that petition. Because, see, end of the day, why the court is the guardian? Court has to look into the future and secure the future of the minor. After he or she becomes the major, it is not the concern of the court because he or she is reckoned to be independent enough to take a decision. Now today, 1/3 share is of the mother.
Only.
And 2/3 share is of the two minor. So you are seeking permission of the court to sell the 2/3 share?
2/3.
Because 1/3 you can yourself sell, no one, so you sell your 1/3.
My lord, only to 1 katha, my lord, land.
One
Only
kata
one
land, one kata land fetching 10,000 rupees, 10 lakhs of rupees. That means it's a very valuable property.
Only 1 katha.
No, one kata or one chita. It hardly matters to the court. When you are saying one kata will fetch 10 lakhs of rupees, that means it's a very priceless property. Where is it situated?
My lord, in the Jalpaiguri under municipality.
Jalpaiguri, where?
My lord, ward number 20.
So one of the lucrative wards must be on the road, on the main road.
Road is municipality area.
I am asking the properties on the main road.
Main road not. It is the byland.
By the
Byland.
how do show that it is a by lane?
My lord, I stated in the petition.
Bring that petition. You file a revisional application without the documents.
My lord, I am only seeking one.
See, whether you are only seeking or you are not only seeking, I said I am not concerned with that. You have come here to seek a permission. Now my conscience, if it permits, then only I will allow you.
My lord, leave it to one day application. 1 day application. Next week, my lord.
See, this matter was there on 29th of April. No one appeared for the petitioner, so it was placed before the next circuit day. Today, again, same situation.
1 day.
Which
My
is
lord,
the
I have already annexed, my lord.
which is the impugned order?
My lord, impugned order is a.
We
My lord, impugned order is 13, order number 13, 5th August 2024. My lord, already I annexed.
see the level of preparation. You are moving an
My lord,
application. I asked
Already
you.
I annexed.
5th August.
5th August 2024.
After that, so many orders have been passed.
My lord, the order was only there 2nd August, 2nd July. 2nd July 2024, there was direction to submit requisite. I have already submit the requisite, but another direction was made, the comply the order 2nd July 2024. It is the impugned. It will be the further evidence. Only further evidence.
Where is the order of 5th August?
My lord, the order number 30.
from the certified copy, 18th of May 2024. Then what is the date? The date is not visible at all.
My lord, the certificate could be issued that way. Not clear.
You have stated nothing in your application.
My lord, property value I stated, here is,
Just
the
a minute.
page number 3 of my claim. 14 lakh.
Yes, 5th August was fixed for further evidence. Where is the order of the 5th August?
My lord, only impugn, the
You read the order, let me see, because the dates are completely illegible.
my lord, certificate of issue not clear.
What is the order? Please read the order.
My lord, today is fixed for further evidence
Yes.
in early, learned lawyer for the petitioner files Hadira comply the earlier order dated to 2 July 2024 at once.
Hmm.
At once.
Peruse the record
Record.
considered
Consider.
regular PO is away.
PO is not due.
So what happened? What do you want?
My lord, here only the dated, I have in previous order.
See, previous order, if I have seen the order correctly, it says today is fixed for further evidence. Learned lawyer for the petitioner files Hajira. The petitioner files requisites along with process fee of rupees 5.
5 rupees.
Issue the same, produced the record, considered the court is the case is adjourned today for ends of justice. What requisites were you required to file?
My lord, the second witness. Or attending the second witness.
Second witness.
Second witness.
Who is the second witness?
My lord, the local person who know the property and the word.
Completely missed. Where is the government valuation? You have not stated anything.
My lord, I have stated 14 lakh.
Where have you stated?
My lord, page number 3. Page number 3 of my claim. Page number 3, my lord. Page number 3. Line number 14.
Appropriate total value is 14 lakh.
14 lakh.
Now, this was made in 2023. What is the value now?
It will increase 1 lakh.
All guesswork. Fifth August, it has been directed to comply. After 5th August, there were several orders.
only one order is comply the order dated 2nd July 2024. It is the impugned. My lord, it will be only the further evidence. Only further evidence.
The court has not closed your evidence. So where is the question of further evidence? You show me that the court has closed that yes, after the petitioner, no one should be allowed to adduce evidence. Where is that finding? You are saying
The petitioner already submit deposition, already deposed.
I have seen petitioner has deposed, but
Require
unless-
one witness, my lord. One witness. Court require one witness. Another one.
No. I can appreciate, but suppose in a suit, you are examining the witnesses. Examination, cross-examination. First witness is the petitioner, cross-examine. So she is discharged.
Right.
Now, where is the question of the closure of evidence? Did the court close the evidence?
No.
That then how are you aggrieved?
My lord, I
Who has
also
stopped
agree.
you from
I
adducing?
have submitted requisite letter. Another date was fixed for only comply the order of dated previous order.
I dated means the requisites. You have deposited the requisite.
My lord,
Now, after depositing the requisites, what is necessary? Do you want to subpoena somebody, or it will be your witness?
my lord, I only.
Have you conducted any trial ever?
Only speedy disposal, my lord.
I am asking you, have you conducted any trial before any court?
Yes.
Yes. What is the procedure?
My lord, I submitted that second witness, further witness, my lord.
So who has stopped
If
you from
necessary.
who has stopped you from doing so? Who has stopped you from doing so?
My lord, this order comply the first or previous order.
Yeah, unable to understand. The petitioner has made an application under the Guardians and Wards Act. Now, the petitioner, being the mother, he, in the absence of the father, is the natural guardian. She has claimed guardianship and she wants to sell one of the properties for meeting the education cost of the minor children. Though it is not clearly spelled out, I take it in the face value. This is all which you have done. Then the petitioner was called for adducing evidence. The petitioner adduced evidence, cross-examined. Now the second witness can be either your witness, you producing it, or the second witness can be a witness to whom you are issuing subpoena. Now, what is that? I am unable to understand, appreciate.
But due to the order is stated comply the previous order. Next order same.
You are
Next order,
appearing,
same.
you are appearing.
Service already completed. I have.
No, I am not asking about the service. Did I ask you about the service?
No.
I am unable to appreciate what is your prayer. If the order of 5th August 2024 is set aside, what will you gain, or if it is not set aside, what will you lose?
I am not I have unable to submit further witness.
Where is the question of, has the judge closed your evidence?
No, my lord,
Then-
there is comply the order 2nd July 2024.
2nd July said put in the requisite.
Because I have already.
What was the necessary for putting the requisite? For what purpose you were asked to put in the requisite?
Another witness.
Another witness. So where you have deposited the requisite. Now where is the order by which the court has closed your evidence? Who has prevented you from? Where is that is what I am asking you from right now.
I have already
20 minutes is over.
Later on, again, directed to submit.
Very well. Again directed to submit. I appreciate, I directed that the witness action should take place. Now, where do I get? You have come before the court. Where do I get? Your evidence has not been closed. Did you make any prayer? Did you make any application before the court? Look here, I have already complied with it. So there is no question of further compliance. Allow me to adduce with it.
After that, the PO only. After
PO is
that-
not only. I have seen the orders. One order records the PO in charge, but later on PO is there. One day it was adjourned. PO was busy in administrative work, and the other PO was busy in writing judgments. This is something is now we are facing. I wish we got time to write judgment by not sitting in court.
My lord, kindly only give the direction to speedy disposal.
Now I tell you, you have annexed the certified copy of the orders. At least 4 times you have taken time. You have asked for adjournment.
No, my lord, that day only.
You want me to show? You come to the first page of the certified copy. How many adjournments did you take? Look there. I have read the entire order sheet.
My lord, get the liberty to withdraw the same.
What? After wasting half an hour's time, you withdraw it, then I dismiss it, imposing personal cost.
My lord,
Take down.
my lord, liberty to withdraw the same.
It is not clear. The petitioner has made an application under section 6 and 8 bracketed 2 bracketed small a of the Hindu Minority and Guardianship Act 1956, read with sections 7(1) within bracket small a, 7 bracketed 1 and 29 within bracket small a of the Guardians Guardian and Wards Act, 1890, before the court of the learned district judge, Jalpaiguri, sometimes in the year 2023. The case of the petitioner is that her husband died on husband died on কি বললাম her husband namely Vishnu Mustafi, son of late Khogendranath Mustafi, died intestate on 4th December 29. The petitioner has prayed for sale of an immovable property of her husband, which has devolved upon the petitioner and two minor children in equal proportion after the death of petitioner's husband. Petitioner says that for meeting the educational expenses and other expenses for daily livelihood, she intends to sell the immovable property which দেখতে পাচ্ছ তো, which according to the petitioner was likely to fetch a sum of rupees 14 lakhs in the year 2023. It is the case of the petitioner that the petitioner has adduced evidence in support of her claim. It is submitted by the learned advocate appearing for the petitioner that one further witness is required to be examined on behalf of the petitioners. The requisite and process fees as directed by the as directed for the purpose of adducing the second witness was deposited on 2nd July 2024, but the learned trial court again on 5th August had directed the petitioner to comply with the order dated comply the previous order for putting in the requisites and depositing the process first. The petitioner is aggrieved by the said order first. Although, I do not find from any of the orders passed subsequent to 5th August 2024 that the evidence on behalf of the petitioner has been closed, thereby debarring the petitioner from adducing any further evidence. But the fact remains that no further evidence has been adduced. Since the matters were since the matter was adjourned on the subsequent dates. The petitioner, instead of filing this revisional application, would have easily made an application before the trial court pointing out the mistake and for recalling of the order. However, the petitioner has chosen to file this revisional application. The revisional application in the aforesaid facts and circumstances is disposed of by directing the court আছে দেখো this is being heard by the London district judge or it is before any other bench? Directing the London district judge to Jalpaiguri to dispose of the petitioner's application as expeditiously as possible in disposal of a petitioner in accordance with law as expeditiously as possible, since the same relates to the interest of two minors. The London district judge if the petitioner so prays for will allow the petitioner to adduce further evidence. No unnecessary adjournment should be granted. The revisional application is being such and such is accordingly disposed. পচা মানে ইন্টারেস্ট ইন্টারেস্ট অফ না ইন্টারেস্ট অফ মাইন্ড করেছে
Lordship, in item number 7, I am appearing on behalf of the appellant petitioner, Sri Shoilen Dash. Lordship, this matter is being led by senior advocate, Mr. Shamol Dash. So would be under his instruction, would be very grateful if Lordship kindly extend the interim order that is expiring.
Sorry.
Uh,
On his behalf, a time was taken on the last occasion. Sorry.
No, Lordship.
Are you in a position to do the matter?
No, Lordship, he will be coming on Monday, 16th of June,
Sorry.
2025.
I have to sit and adjourn when he will, by consulting the almanac and ephemera, he will come and I have to sit for that. How many time I will be giving adjournment? Sorry.
Lordship, this is the first time we are.
If you can do first time,
This is the first calls. Lordship, it was not called earlier, Lordship.
If you are not appearing in a matter, don't make unnecessary prayers for adjournment.
I apologize, Lordship.
Yes. What is, you are appearing for whom? Has the copy been served?
Lordship, we have served the copies and this is the affidavit of service. Would be very grateful if Lordship keep it on record.
By an order dated 29th April 2025, the petitioner was directed to serve a copy of the application upon the opposite parties, full stop. দেখি এফিডেভিট সার্ভিসটা দেখবে। Affidavit of service filed in court today is taken on record. It appears that from the said affidavit that the opposite parties have been served. The opposite parties, most of the opposite parties remain unrepresented. The petitioner seeks an adjournment. Let this matter be adjourned and shall appear on. সোমবার সোম।
Very grateful, Lordship.
Item number 8.
My lord, I appear on you. For the petition on behalf of item number 8. Wait, please, may I?
Yes.
So.
What is the matter about?
Yes, my lord. My lord, this application has been preferred on rejection of Order 7, Rule 11, what we have filed before the district judge, third court, my lord. Now, my lord, if I may take you to the summary of the case, my lords, is that this is a matrimonial dispute, my lord. My lord would find out from the petition, my lord.
You are for whom?
For the wife, my lord. Petitioner is the wife, my lord. My lord, my lord, in page number.
Yes, tell.
My lord, upon page number 25, my lord would find out that we have filed an PWDV and protection and complaint under section 12 of Protection of Women from Domestic Violence Act.
DVR.
Yes. On 5th February 2024. On 5th April 2025, we have received an order of restoration of matrimonial residence with police protection with a room to be allotted. Subsequently, my lord, police was instructed to assist the petitioner. Police have filed the compliance report to that effect, my lord. So, my lord, then they came up on 20th April, my lord.
Who came up?
Husband. For an application for dissolution of marriage and on the grounds of cruelty and on the grounds of desertion, my lord. Now, my lord, what has the desertion to speak about? The desertion says that there has to be an immediate two years desertion, my lord. Whereas in the plaint of dissolution of marriage, they have admitted the fact that yes, we are aware of the judicial order whereby
the restoration of matrimonial residence have been made.
Hmm.
Now, my grievance is that, my lord, my first grievance is that, my lord, a plaint cannot be part accepted and part rejected, my lord, which my lord will also find out from the certified copy of the order impugned, my lord. My lord, may if I see the order impugned.
Very well. This is an application.
My lord, affidavit of service have been served, affidavits have been served, my lord, and next date is on the 26th. Kindly grant us a stay, my lord.
You know, this is an application. Arising out of an order rejecting an application under Order 7, Rule 11 of the Code of Civil Procedure 1908, in short CPC, filed by the petitioner bracket a wife for rejection of the matrimonial suit filed by the husband for restitution of
Dissolution of marriage.
for dissolution of marriage on the ground of cruelty and desertion. Although a copy of the application has been served, in terms of the direction given in the order dated 29th April 2025, but no one appears on behalf of the opposite party. Let a fresh notice.
My lord, kindly affidavit of service.
Oh,
We have served first.
কি বললাম? না না ওর আগে হচ্ছে
Also a copy of the application has been served in terms of the direction given in the order dated 9/7, but no
ওখানে
one.
তো ওখানে একটা সেন্টেন্স, the affidavit of service filed in this context is taken on record. Only for the ends of justice, a fresh notice be issued to the opposite party, as also to the learned advocate representing.
My lord, we do not know who is the advocate, my lord. It's upon admission, my lord. We do not know the advocate who is appearing. It's upon admission.
Sir, please allow me.
My lord.
The learned advocate representing the opposite party in the trial court. Which district this is?
Jalpaiguri.
Jalpaiguri. So come back.
My lord, may I say something, my lord? We have spoke with the lawyer in the district court. They have said that they have retired from the brief and not to bother them with this brief.
Serve them. Let us see. Let this matter appear on
My lord.
Wednesday.
Very well, my lord.
Huh? Passover matter good ডাকো তো।
Passover matter, item number 1. Item number 1.
হ্যাঁ কেউ নেই।
Item number 1. Anybody present?
আইটেম নাম্বার 1টা কি আছে দেখি তো। এটা এর আগে একদিন ডাক হলো না? হ্যাঁ
Yes.
Who is your other side?
Lord, they were served, but they have not appeared.
Very well. You have to satisfy me
Yes, Lord.
that arbitration proceedings, section 11 proceedings for appointment of arbitrator cannot be proceeded with in view of the corporate moratorium under the IBC.
No, my lord, that is not my argument. If your lordship wants to proceed with this application and appoint an arbitrator, I do not have a problem with that. But my only submission before their lordships were before
এই
the court,
IBC টা দেখো তো আছে কিনা?
because my lord, the
Insolvency and Bankruptcy Code.
my lord, I'm getting one for your lordship. Lord, this is the
Let me see, because I need this. Yes. বিরাট বই দিয়েছিল এখন খুঁজে খুঁজে বার কর। Yes.
my lord,
Moratorium is operating under which provision?
my lord, IRP has been appointed.
Yes, resolution.
Yes, resolution professional has been appointed.
Maybe.
He's
Section 7 application was made.
Yes.
And now the moratorium is operating under which provision?
that I'll have to look into,
Okay.
because I'm only partially aware of the NCLT proceedings. And my lord, as
See,
per my client's
the
instructions.
difficulty is that you obtained an order, learned counsel for the petition of the person application section 11.
Yes, Justice Tandon's order.
Document on which the petitioner has been impounded. However, in the meantime, a corporate insolvency initiated with regard to the borrower company. As such, the present application cannot be moved at the present juncture. Accordingly,
Lord, sees the last order dated.
I've seen that.
5th of
Justice
March.
Tandon.
Yes.
Where do you get that? That the section appointment of arbitrator cannot be done.
No, if your lordship wants to, my lord, proceed with the appointment of arbitrator, I do not have a problem with that. But ideally, this would create, my lord, an anomalous situation because
What anomalous situation?
because my lord, the opposite party company has gone into liquidation admitted. And that procedure is
Has not gone into liquidation.
my
Sir,
lord, insolvency proceedings has been initiated.
what is insolvency proceedings? Insolvency proceedings that you are required to be declared as insolvent or
Yes.
be unda.
Yes.
Now, what is the why is the resolution professional appointed for corporate restructuring?
Yes.
He shall be preparing a scheme for revival of the company.
Yes.
Only if the revival scheme fails, then the company will go, will be wound up.
Yes.
So why are you saying that?
Because my lord, I'll take this point, sir, before the arbitrator. Your lordship may proceed with the appointment.
No,
Because admittedly, there is an arbitration clause,
yes,
and I have, my lord, paid an amount of rupees 2.5 crore for purchase of this property, this particular tea garden. And my lord, there is an arbitration clause in the agreement. So an arbitrable dispute has arisen. Yes, this honorable court has a power under section 11 that may be proceeded with. These points that I am taking before your lordship, since your lordship is of the view that this may not be taken up at the stage of section 11, I would take this up before the arbitrator.
because the arbitrator will
Yes.
decide. The court has no option but to appoint an arbitrator. Now you show me the provision that's which I wanted to see, that are at the restructuring stage. Okay, বইটা দাও. No, you take back your book. I have got one.
Yes.
At the restructuring stage, the moratorium operates.
Perhaps it is section 14.
No. See, this procedure, if you look into under the old Sika Act, the CKA, there was a moratorium. Now you will find Chamundi mopeds, the judgment,
Okay.
the statutory dues, payment of rent. These cannot be stalled.
In fact, my lord, my client has taken over the management of the subject tea estate. They are running it. The petitioners are. They're running it. They're paying the wages of the laborers. The cycle is moving. But, my lord,
You have taken it from the RP.
no, my lord. Before that, we had taken possession of the tea garden from them, from the opposite party, and my lord, subsequently, all of this problems started.
What was the agreement between you and the?
For transfer of the lease that was originally granted to them by the government of West Bengal.
Transfer of the lease.
Yes, my lord. Assignment. Essentially for assignment.
Assignment of what?
Of the lease of the tea garden that was originally granted to the opposite party by the state of West Bengal.
So the difficulty is that in these sort of cases, you have two things. One, whether it is a leasing out of an immovable property or leasing out of the business.
This is, my lord, only the immovable property, because this.
No, the immovable property, the tea garden, along with the factory and other
Yes.
components, is the business of the respondent or the defendant.
Yes, my lord.
Now, what they have given you? They have given you they have let out you the business.
My lord, the original agreement of the original deed of lease, which was granted to the opposite parties by the state of West Bengal, the entire scheduled properties that form part of that lease, my lord, is also part of this.
Maybe it has to be.
So the entire thing that was leased out to them,
See,
we have, my lord,
see,
made an agreement to.
Sir, it's a company.
Yes, my lord.
The defendant is a company. Now, defendant company is a juristic entity. Now, what is its object? Its object is to carry on business. What is the business? Business of tea manufacture and sale. Now, granting you lease of the immovable property is one part, because that will be a suit for land, whatever may be.
Yes.
It has to be. Now, whether the business has been let out to you, that you will be running, you will be manning, you will be operating the business. The moment you said so, then it comes to my mind that because there is a difference. There are reported judgments. I can even give you one which considered all the other particulars, Bhartiya iron. Yeah. So, it was an iron foundry. So the resistance there was in case of eviction or recovery of possession, that it is a tenancy of an immovable property. The court rejected it, single bench, division bench, and Supreme Court has also turned it down. Because following the Supreme Court 76, the Supreme Court then probably 75 or 78 Calcutta alliance due to this judgment. So what is it? Now see, if you look into the concept of winding up, arbitration and winding up was held by the Supreme Court, firstly by Calcutta High Court, then by the Supreme Court, that it can operate parallelly. Why? Because winding up is a statutory provision, while arbitration is a contractual matter. Now, that is where I am asking you, if we borrow that concept, does IBC is a statutory provision, and arbitration is a contractual provision. If we go by the old principle, then whether a moratorium will operate in the way of proceeding with the arbitration. Because if you look into the language, section 14 probably. See, section 14, come to section 14, 13 and 14.
I was looking at-
Subject to provisions, see, 13 says, the adjudicating authority after admission of an application under section 7
Yes.
or 9 or section 10 shall by an order declare a moratorium for the purpose referred to in section 14. Now, section 14, subject to the provisions of subsection 2 and 3 on the insolvency commencement date, the adjudicating authority shall by an order declare moratorium for prohibiting all of the following, namely, the institution of suits or continuation of pending suits or proceedings against corporate debtor, including exercise of any execution of any judgment, decree, transferring, encumbering, alienating. Then we are concerned with A, proceedings. Now, proceedings will it amount to proceedings under section 11 or not?
11.
That is the only issue. If that be so, then obviously the court has to stop. But at the same time, how long can it be? What is the situation? How long can it be done?
Lord, if my lord, it would cause prejudice if your lordship dismisses this application, because this is one of the claims that I have over the property. There is also a section 9 pending that the district judge has, my lord, agreed to adjourn. And this
Which one?
there's section 9 application pending.
Very well.
And my lord, a similar section 11 application for appointment of an arbitrator.
Section
pending.
9, section 9, to some extent, it is an interim protection.
Yes.
It does not adjudicate the right, suit or proceedings. Now, under the classification of proceedings, whether section 11 application will come or not. Because section 9 comes within the ambit of proceedings.
Proceedings.
Because section 11, we are not adjudicating anything. Only thing whether there is an arbitration agreement, there is a claim or something like that.
Your Lordship may proceed with the appointment. Because
But I have a doubt.
my Lord is right about the fact that section 11 does not adjudicate upon any issue. It merely appoints an arbitrator. The arbitrator, if he commences the arbitration, that would be adjudication. So before the arbitrator, I may come up with an application that you
That is what
do not continue with
that
this.
is what I have to also look into. And I asked you this question. You are supposed to assist me. You did not do
My Lord,
anything.
give me one day's accommodation.
Then I have to do the homework in the
No, my
weekend.
Lord, certainly not. I'll do the homework. Give me 1 day's accommodation. I'll come prepared on Monday. The only point is whether section 11 would be affected by this moratorium. or not.
Yes, under the proceedings on the word proceedings under section 14 will include an application under section 11.
11. Monday, my Lord. I assure your Lordship, I'll come up.
As per item number 2.
Sure.
In item number 1, Mr. Roy was volunteering to be amicus. Instead of my lord working, Mr. Roy is saying, I will do the homework. My lord, in item number 2, the crux of the problem is this. There were certain parcels of property, movable, immovable, of belonging to 4 brothers. Now, the 4 brothers finding it difficult to enjoy, amicably agreed to appoint one arbitrator. An arbitrator was appointed.
It was a partnership.
No. There were different types of businesses. It is family property, family undivided.
Settlement, family settlement.
Family settlement.
Family settlement through arbitration.
By way of arbitration. The arbitrator passed his award. At a considerable point of time, because the award of the arbitrator was not being given effect, an execution petition was brought. During that, it was found out there is mathematical error. Now, whether it is error or not, that is for the arbitrator to decide. Now, at that junction, my lord, 33 cannot help the petitioner. Neither of the parties, because 33 says both of the parties.
It has a time limit.
30 days. 34 cannot be pressed into because neither my learned friend's client is agreed with the award, neither my client is agreed. A certain mathematical calculation appears to be wrong. 37, no question comes out of. So the only recourse open to the petitioner was to come before the honorable court with a prayer, either the earlier arbitrator be redirected or a new arbitrator be appointed. Now, my lord, there is a judgment, I was trying to find it out, where it says, it has been said by the Honorable Calcutta High Court as well as the Honorable Supreme Court, that even after passing of the award, the arbitrator retains that limited jurisdiction to clarify and correct an award.
Yes.
And
Yes, that
in
is
cases,
that is what I was saying. I have the noting.
and in cases, even the court can.
See, the difficulty is that if no one is aggrieved, then by consent of parties, I can send it to the arbitrator for that same arbitrator for the mathematical correction.
First of all, that is the mathematical error.
Now, Malord, one thing I should add before I finish. But on the last occasion, Mr. Sarkar has filed his objection to my application, and I was supposed to file a reply. So we could not prepare the reply. Actually, basically, we want to file the reply before the matter is taken.
No, yeah. The application is under the nomenclature section 11.
Yes, my lord.
How can section 11 take? See, the award is already there.
My lord,
My God, is given effect to in 100% terms.
my lord, let me
That
come
is-
up with the reply.
That is
Your
on a
lordship will
merit,
decide.
that is on a merit, but how section 11 applies?
I had
34, at the highest you can make an application on 34.
That is also time for. That is also time for.
My lord, I have already made it clear to your lordship that I have been given a right to file a reply by the earlier order. I want to submit my reply, let it be decided by the honorable court in that way and that way.
Because he has taken so many times. It is very painful for me to come again and again.
He can appear virtually.
He has taken so many times.
No, my
It's
lord.
only case of-
No, my lord.
It cannot be a fanciful desire of a person to come to the court and you take a time at his week.
My lord, rather I am a regular visitor of the court. My learned friend is fanciful visitor.
I was regular.
These types of submissions should not be made in the courtroom.
No question of seniors, no question of attacking each other. That is not.
No, my lord, what is this fanciful visitor?
No, I'm not telling you. You
No. He has used the word at the whims and fancy of a litigant.
Yes, definitely. I'm not telling you. Please go to the ownership. I am not saying a single word. Please see the ownership.
See, as it is, I have doubt about the maintainability of the application.
Invoking her element, but it's very much clear. He also filed a petition before the senior division and took time and ultimately withdrew and filed here. So
No, it was not withdrawn. It was not withdrawn. It is still pending.
No. I'm seeing the ownership. I'm seeing the ownership.
See, you want your matter to be hard.
Yes.
So, showing the order sheet will not help you. Because if I refuse him the prayer to file reply, you know, he will get it corrected in a different manner. And that will delay your, will put an end to your entire effort. The only option which is available under the Act, subject to hearing, is that if the parties agree, then the time.
The order given in the year 2014. With family property, 4 companies, 4 ballots, given 4 companies, and the variation was taken on mutual agreement. And the variation, according to variation, they got some lands.
Yes,
Opportunity.
yes.
That land was also given to the promoters.
Hmm.
They constructed thousands of flats. That has been sold out. So what remain left? So after the lapse of 11 years, because they have accepted that they are not agreed, all of them has given all the lands, comprising of more than 1,000 acres to the real estate owners.
Oh.
They
Take down,
construct-
take down.
So there's nothing.
Although, comma, this court has a doubt as to the maintainability of the petition. Particularly in the context of the facts of the case. Yet for the ends of justice, since direction for affidavits have already been given, the time to file affidavit in reply is extended. Mr. Mujumdar, take a short time by Thursday. By Thursday, let this matter appear on Friday, 20th.
It's fair.
তারপর কি আছে? মামলা তো কেউ করতেই চায় না।
Item number 3. Item number 3.
So in this case, they have served the copy of the judicial application. We will file every week our.
Why? Unless I hear out you have a case to file. It will take how much time? Half an hour, 45 minutes, 1 hour.
This 10-15 minutes will be different. Already will go over.
It may so happen I may sit singly after completion of the division bench, because in division bench I find that no one is
All those matters will be.
all star or all star. Very well, not today করে রাখো, দেখি তারপর সোমবার যদি হয় হবে। আমি চেষ্টা করলে তো হবে না, ওনাদের হচ্ছে সিনসিয়ার হতে হবে। 2-1 জন বাদ দিলে কেউই মামলা করতে চায় না, খালি অ্যাডজার্ন। চলো আর কি হবে। হ্যাঁ
In this case, my lord, I am appealing to the appellant accused. But the matter, there is a delay and my lord Justice Bakshi was pleased to allow that, but admit the appeal. And there was an application, direction was there also, my lord Justice Bakshi, that liberty is granted to file an application for bail. But my lord, here, two persons are there. One is a state, another is the defector complainant.
Yes.
My lord, state has been served. But my lord, in the case of POCSO, there is a rule is there that we have to give the notice to the
issue. ওখানে একটা ইয়ে লিখে দাও, the
Lordship, I am appealing on the behalf of the applicant.
Uh,
Lordship, the appeal is already been admitted and is granted to prepare the paperbooks with the department. I don't know why it's.
No, this is appearing by mistake. This is a single bench matter. ওই জাস্ট হচ্ছে ইয়ে করে দাও this is a matter matter be stayed before the division. This is a matter to be heard by the learned single bench, but has been mistakenly placed in the list of this bench. Let this matter go out of the list for being placed before the appropriate bench.
Much obligation. Item number 3 under.
My lord, item number 3, I am for the respondent number 6. On the last occasion, nobody appeared yesterday, my lord, for the appellant.
You are appealing?
Another respondent, the primary board. Millard was minded to dismiss this today if no one appears.
Yes, my lord.
This is the kota kodin
My lord, previously it was dismissed once. Thereafter they restored. Thereafter on 21st of April they did not appear. Thereafter on 28th.
The matter appears to have a checkered history. The appeal and the connected application was dismissed for default. দেখি রেকর্ডটা দেখো তো অর্থ দেখো তো কবে ডেট গুলো আছে dismissed for default on blank, ঠিক আছে, but was subsequently restored even before the previous
October 3rd, 2023.
3rd October 2023. Restored হলো কবে?
Restored
2nd of April.
April 2025.
And restored on 2nd April 2025. তারপরে দুটো adjournment হয়েছে কবে কবে?
21st of April they did not appear. 28th of April they did not appear.
Yes. The appeal and the application was adjourned on 21st April 2025 as also on 28th April 2025.
And thereafter on 20th of May 2025 they also not appeared.
The matter was again adjourned on 20th May 2025. Before this circuit, the matter was called on 9th and 12th when no one appeared. Even today, packeted date there, no one appears in support of the appeal poster. No one has sought for any adjournment. No one has applied to represent the appellant through virtual mode. The matter, the appeal and the connected application is dismissed for default.
But I am for the respondent number 6, my lord.
You give your appearance in the chat box.
Yes, yes. Grateful, lordship.
Item number 4.
I'm applying for the this is an application for restoration. There is a delay of 106 days, lordship. Let me serve and come back.
This appeal and the connected application was dismissed by an order dated
8th of January 2020.
8th of January 2025, after recording that the matter was adjourned on 17th December 2024, or 25th December 2024, and 12th November 2024. এটাকে আগে করে দিও 12th নভেম্বরটাকে 12th নভেম্বর 17th 25th ডিসেম্বর কোর্ট হলো কি করে ভুলভাল করেছে কিছু December 25th November. তাহলে 17, 24,
November, 12 November, 17 November, 17 December.
17 December, first of. This is the restoration, this restoration application has been filed This restoration application being Can 2 of 2025 has been filed on 23rd May 2025.
Delay of 160.
কি বললাম this application কি this application for readmission of the appeal and restoration of the application being Can 1 of 20 Can 1 of 2024 being Can 2 of 2025 has been filed on
23rd.
Let a copy of this application be served on the respondents. Let this matter appear in the next circuit. Appear before the next circuit, subject to its convenience.
Item number 5, under order 11, order 41 to 11. Item number 5.
হ্যাঁ একটাই বেঞ্চ চলছে এখন সেকেন্ড বেঞ্চটা কোথায় গেল লোকজন করবে না
Item number 6.
সেই কালকে হিলি হল কেটে কেটে টাইম নিবে
Item number 7. Item number 7.
Item number? Yes.
Some technical issues, the conducting advocate is not able to appear through virtually. Kindly fix the matter on Monday.
Sorry. Ask him to get connected. We are passing it over.
This time continues to touch by after it also that it's showing
দেখো তো অ্যাপ্লাই করেছে কেউ
showing the service temporary.
No one has applied. Evidence under? No. That he has not applied.
Screenshot.
Evidence under 65B.
কোনটা
এই যে
ও
এক্ষুনি তো পাওয়া যাচ্ছে অ্যাপ্লাই করে ask him to get connected.
Item number 8, under civil appeals. Item number 8. Item number 9, under application civil.
এটাও আসেনি এটাও দুবার হ্যাঁ
ডাকতে থাকো যেই আসবে না ড্যাচ অ্যান্ড ফুয়াল
Petition number 10.
Then for the respondent.
Very well, pass over.
Item number,
You are also for respondent?
Yes, we are both.
item number 11.
এটা আর লিখে রাখো, ঠিক আছে, আর লিখে রাখো। আর আগেরটাতে না ওই এডিজে করে দেবো, অ্যাডজার্নমেন্ট প্লেট করে দেবো, তারপর দেখবো কবে।
Item number
10.
under application civil.
Yes. Yes, what is the matter?
We have challenged the preliminary decree.
On what ground?
Lordship, in this appeal, I may be permitted to file an supplementary affidavit annexing the deposition. The court trial. Of the deposition before the trial. In my lord, we will be needing those evidences. And
No,
also,
what we are hearing, application of the appeal? Right? What we are hearing, application of the appeal?
whether there is a can application for stay.
So, in case of the application, do we require the evidence?
No, my lord. My lord, it is
Because the
the
evidence will be
in the merit of the appeal.
The state is,
ah.
yes, and possible of the person final without the doctor. Preliminary degree arrange করেছে আর they will maintain status. পেপার বুকে ডিরেকশন
প্রিলিমিনারি ডিগ্রি হলেও তো হচ্ছে তোমার ইয়ে থাকবে না, তোমার রাইট তো কনফার হলো না।
সে একটা ডিক্লেয়ার হয়েছে।
হ্যাঁ, what is the why are you asking for stay?
Well, because they are proceeding with the final degree.
Now, what is according to you the error?
But there are lots of errors, my lord. Lots of errors, my lord. Firstly, apparently, my lord,
Who are you and
I
who
was
are
the
the
defendant.
you
You
are
are
the
one of the co-chair.
May I?
Yes, yes.
My lord, the admitted fact is that one Kheer Mohan Rai and his two brothers bought certain quantities of land from the original recorded tenant. And that land came up to 4.62 decimals.
4.62 acres.
Acres. Subsequently, my lord, there was a partition between the brothers and Kheer Mohan Rai got 4.54.
4.54. 4.5 acres.
Out of 4.62. By the deed of partition, there is the admitted position by friend Mr. Raimos and Mr. Gold.
Fire partition.
Yes, in the pleading, but it is in the pleadings, plaint.
It is
In the pleadings of the trial. Plaint. Now, Kheer
partition
between the three brothers.
uh,
Now, Kheer Mohan Rai came to be owner of 4.54 acres of land after the partition. Now, my lord, after the partition, Kheer Mohan Rai gifted 3 acres of land to his son Damilai. And as my lord, the Honorable Justice Chatterjee was asking me, I am the legal heirs of Damilai. The son, plaintiffs are the branch that comes from the daughters of Kheer Mohan Rai. Subject to correction by the record, and I think I am correct in that aspect.
oh,
Now, the plaintiffs, they said, out of 4.54,
বীরমোহন ভাইদের মধ্যে খিটটা খেয়ে নিয়েছে, যার ফলেতে আজকে এই সমস্যা।
my lord has found that the applicant
Okay, they will, court will proceed, but not to pass any final order without leave of the court.
Lordship,
And you all maintain status quo.
Lordship. And my lord, let the paper book be prepared.
Paper book, prepare the.
The appellant,
Let us see if some key.
the appellant has challenged, the appellants have challenged the preliminary decree dated
The junior degree dated 28 February 2025. Yes, is.
28th February 2025, passed by the learned civil judge senior division Jalpaiguri in title suit number 82 of 2019. First. In this application, the appellants are seeking stay of the preliminary decree. After hearing the parties and considering the materials on record, we
are of the view that a good arguable case.
We are of the view that the petitioner, that the appellants have been able to make out a prima facie case. Post. The balance of convenience and inconvenience is also in favor of the appellants in as much as the appeal will become infructuous if the trial court is permitted to proceed with the suit and pass the final decree. Post. No. সেটা clarify করবে, proceed and pass the final decree. Post. There is also a likelihood of multiplicity of judicial proceedings if the appellants are not given an interim protection. Post. In the aforesaid facts and circumstances, the trial court will be entitled to proceed with the but shall not pass the final decree without the leave being specifically obtained by the parties from this court. Parties করে দিচ্ছে, নাহলে কি হবে, ওই স্টেটা নিয়ে বসে থাকবে আর ও ফাইনাল ডিগ্রি যদি পাওয়ারও থাকে ও আসতে পারে, ঠিক আছে। The parties shall maintain status quo as to the nature and character and position
of the Supreme Court as on date.
In respect of their respective shares declared under the preliminary decree dated 28th February 2023. Until disposal of the appeal or until further orders, whichever may be earlier. The appeal has been admitted.
First step.
First step, paper book direction. তারপর ওই ইয়ে করো তোমার হচ্ছে let informal paper books be prepared. না ওটা তো নিচে সুটটাই চলবে না, ও তো চাইছে এটা এটা কল ফর করলেই সুটটা ওখানে বন্ধ হয়ে যাবে।
No, my lord.
হেঁটে
Let the informal paperwork be prepared.
Yes, informal.
হেঁটে ওই ট্র্যাপে ঢুকতে রাজি না।
No, no, there is no trap. It is open passage. My lord, maintain without any difficulty.
Be prepared by the appellate upon settlement of index of the papers to be incorporated in the informal paper book by the respondents. The sufficient number of people, the appellant shall be, the parties shall be at liberty to mention for enlistment of the appeal once the paper books are made ready.
My lord has given a timeline probably for the paper books. My lord, I just get to it.
No timeline.
3 weeks from date করে দিন।
Yes,
তোমাকে ওই জন্য দেখা হবে with your leave, my lord.
Item number 11 under application schedule. Item number 11.
Yeah, the petitioner lordship, section 5 has been filed lordship, but service not even completed.
When was the matter time expired? What is the appeal about? Are you aware of it?
30,
Huh?
30, 10, 1 day lordship.
See, in our junior days, we used to aspire for these sort of opportunities where the senior was held up in other court so that we could get an opportunity to move a matter, do a matter, to submit before the court. Why don't you grab this opportunity?
preliminary degree partition suit.
দিলে কতদিনে?
63 days, according to them.
কবে ফাইল করেছে দেখো?
তা সত্ত্বেও আমি এপিডেমিক করে অ্যাকাউন্ট করেছি বলে দিচ্ছি।
না এই তো ফাইল করেছে
13th day of May 2025, affirm section 5.
সেকশন 5, হ্যাঁ
Been filed lordship,
13th May 2025.
I have to serve it.
which district? Which district?
Is Coach Bihar.
Oh, next subject.
You the junior, we are aged person, we are finding out. Information for you.
Yes, the appeal arises out of a preliminary decree passed in a partition suit. Preliminary decree dated কত দেখি? Preliminary decree preliminary decree dated 11th December 2024 passed by the learned civil judge senior division Sodor at Kuch Bihar in title suit number 8 of 2016. The appeal has been filed beyond the stipulated period of time and as such is accompanied by this application for condonation of delay. Full stop. Full stop. Although this application was filed on 13th May, right?
Appeal and application.
has been filed on 13th May, but service has not been effected as of date by the appellate for reasons best known to the said appellants. Let a copy of the application appellant হবে বুঝেছো appellant দেখে নিও let a copy of this application being can such and such be served on the respondents within served, let this matter appear before the next available circuit bench subject to its convenience when the petitioner, when the appellant shall file an affidavit to demonstrate service on the respondent. Yesterday you took time. You did not appear in the first call. Only one court is functioning, and you want us to believe that he.
Item number 12, under the heading tribunal repeat.
For the respondent. For that.
Arising out of?
It's an order passed by the taxation tribunal. Although a procedural order, but nothing on substance. If kindly, I'll just give your lordship a backdrop. With the affiliate is a public sector organization. It is the NHPC. Now, in connection with the financial year 12-13, an assessment order was passed on June 2015. A demand of about 2.73 crores were raised. The demand was raised on the basis that the goods which were used by the contractors, they were subsequently all those machineries, heavy machineries which were used for the purpose of construction of hydroelectric dams, etc. Reselling of the goods, etc. This was the subject matter. The appeal has no connection with the crux of the substantive dispute. Now, subsequently, immediately thereafter on August 2015, an review application was preferred. Review application is stipulated under the statute. Whenever in an assessment order, before appeal, one can prefer a review before the assessing authority. Now, along with that review application, the statutory fees that was required to be deposited, according to our records, by way of a e-challan dated 24th August, that is 2 dates prior to the preference of the review application, that the statutory fees was also deposited. Now, respondent number 4, that is below the assessing authority, he was also intimated that we have preferred a review application. Now, thereafter everything went silent. No notice was served upon us with regard to hearing of the review application. All of a sudden, in 2022, we receive an communication from the respondent authorities seeking payment of the amount which was raised against us. Against that communication, we immediately said that on so and so date we have already preferred and review. The review is still pending. So therefore, the question of payment at this stage won't arise. Now, subsequently, and along with that, when this communication was made, we were intimated that your review application has already been rejected in 2015 on the ground that the statutory fees was not deposited. we, by way of a subsequent communication, we sought for a copy of the order. They kindly supply us with a copy of the order so that we can pursue appropriate remedies. A copy of the order was supplied. The order was dated 2015 but certified in 2022. That endorsement is there. Against that order, my lord, we went before the tribunal. Now, my lord, the tribunal probably, my lord, the facts were not placed before the, as shall appear from the order of the tribunal, the facts were not placed before the tribunal properly. My lord, the tribunal completely went into a different trajectory, and my lord, our application before the tribunal was rejected.
Tribunal has specifically observed
Yes.
that the petitioner had knowledge about the fate of the application for
Yes.
review.
Yes.
Otherwise, it could not have obtained a copy of the order
Yes.
dated 27th August 2020.
Absolutely correct. My lord, that is probably, my lord, factually incorrect. I subject to correction because upon perusal of the order which was annexed in the tribunal application, it will appear that the order is certified in 2022
So
upon our application.
I review application before the tribunal.
That's what, my lord, tribunal do not have the power of review, my lord, at this stage, because and final order has been passed, my lord. My only remedy is before the division bench. My lord, my prayer is very innocuous. My lord, I am only saying let my review be considered. And it's a statutory remedy. And my lord, I will
Review has already been rejected.
on the ground that statutory fees has not been deposited, not on merits. And my lord, the statute, my lord, I will just place the provisions and the rules. The assessing authority, while considering the review application, there are two circumstances. One is the assessing authority hears out the review. Two, the review is rejected at the threshold on
What do
technical
you say?
grounds.
Public sector undertaking. What do you say?
But there has been, first of all, a contributory negligence. They have filed the review in 2015 and they come up in 2022 saying that we were not aware that the review has been dismissed. It was dismissed way back in 2015. They ought to have been vigilant.
Before my friend takes over.
They did not take any information regarding that said review. Whether the same was pending
before
or
my
whether it
friend,
was said.
before my
And the
friend takes over,
allegation
just 2 lines
that
more.
they have made that it was certified in 2022. Obviously, they have applied.
You
for
are
it in
appearing
2000.
for whom?
I am appearing for the state respondents.
Now
Taxation authority.
tell us, did you communicate the order of dismissal of review to them?
No.
Well, it was communicated.
How?
It is a specific amendment, but it was communicated.
My only addition, just 2 lines.
Just 1 minute.
The only thing was that
First you show us.
but it takes up my affidavit in opposition. But it takes up paragraph number 9, that is at page number 4. Well, if I may read the relevant part, that the statement made in paragraph number 7 of the writ petition is denied and it is submitted by the respondents that the petitioner was already communicated about the rejection of review petition along with cause by a letter memo bearing number 602 dated 27/8/2015. Further, there is no mandatory provision of hearing before
Show the receipt copy.
But this is annexure A. Annexure A to my.
There is no endorsement of receipt.
Receipt copy. Show the receipt copy.
Probably erroneously, my lord, they wrote it, but was not subsequently communicated.
No,
that can be a scenario.
This
Show
was-
the receipt.
Well, this was communicated, this was received by them.
Where?
Though it is not-
Show us the receipt.
What I find from the annexure A, my lord, it doesn't bear their signature, but this was handed over because I had
See, you have communicated, either you have communicated through peon book or through messenger or through postal authorities.
No, it is actually handed over to the learned advocate who had filed the application.
Without
That is what-
his signature being
My lord, I'll seek the necessary instructions and I'll obtain the copy of the peon book in that regard. I'll do it. And my lord, even
come back on Tuesday.
Yes, my lord, even then, one of the requisite payment of the statutory fees, my lord, he has paid only rupees 200. My lord takes up page number. This is 34 of the 37 of the petition. My lord would find from the slip that the payment was made. Payment of total amount of 200 was made. Whereas, as per the provisions of section 88, the minimum payment that is to be done is rupees 400.
Milord, that
It
is
not
why,
even-
Milord, that is
he
why
did
the
not even
rules, that is
make
why
payment
the
of the entire
rules,
requisite fees, statutory fees.
Milord, that is why the VAT rule
That is the
specifies
reason.
that
it
if
was
the
rejected.
application,
The plain and simple theory is no one should be rendered remediless.
Definitely.
This,
I bowed up to that.
the Supreme Court has clarified.
Bowed up to them.
You are an assessing authority.
Lordship.
If you are entitled to recover anything, you should not be, your power should not be fettered. At the same time, they are a public sector undertaking. Now, if it was an individual, one can allege that for his personal gain, he has done this or done that. Now, this is a public sector, no one's gain, only loss and loss. So let us not force further loss.
That's your
If you can show that it was
Lordship, I'll
it was
come back with
it was delivered, so then he is out. If you are unable to show, then probably we will grant the review application to be considered afresh. Whatever cost they had to.
It was even not admissible, entertainable on many because the statutory fees, complete statutory fees had not been paid.
Very well, that we. No
but if the
difficult.
review is considered, no one is prejudiced. I don't understand this, Milord, adversarial fight here. If a review application of a public sector undertaking is considered, Milord, who is prejudiced?
Well, the being a public sector enterprise, they ought to have been more vigilant.
Only,
They file a review, my lord,
and you show your,
in 2015,
you show that you have
and they
dispatched
say
first.
they have only
Show
received
your
information
vigilance first.
in
Then you
2022.
raise your voice.
Mr. Ghosh, only prejudice is the bench. Because has to hear all these things.
But
No law is involved, only service of.
No, Milord, one law is involved that in a review, even if it is dismissed on technical grounds, still an opportunity of hearing has to be provided, which admittedly they have not
in a
provided.
review,
It's an ex parte order.
as per the rules, no hearing is required.
Sir, you go through the rules, I will place the rules.
Yes,
Today,
obviously.
come back on Tuesday, I have a copy.
Sure.
Even if it is rejected on technical grounds, an opportunity of hearing is mandatory.
It has to be admitted first. Then it
And
then
it's an ex
opportunity.
parte order.
Not an expert here.
একটা order record the department oblique respondents are directed to place before the court the document or documents to demonstrate service of the order of dismissal of the review petition upon the petitioner bracketed review applicant on the next date. Let this matter appear 17 তারিখ.
Item number 13.
Yes. Who is for the respondent? Who appears? You are for the state is appellant. Who appeared? You don't have any idea. Any advocate appeared before the tribunal? Before the tribunal.
Before the tribunal, some advocate appeared, but I believe from Calcutta. Then I may because I had already served a notice upon the petitioner for the tribunal concern.
Yes, Mukhopadhyay, yes, Bhattacharya.
the respondents remain unrepresented despite service. However, comma, for the ends of justice,
One Somen Biswas advocate had appeared for the petitioner before the tribunal.
কি বললাম তোমাকে? The appellant petitioner is directed to serve the respondents once more, along with the once more, and shall also effect service on the learned advocate who represented the respondents before the tribunal.
Service on the return of the book.
And file affidavit of service on the return.
Affidavit of service.
No, you will file a fresh affidavit of service.
This may be kept on the
Showing
tribunal.
compliance with this order.
I'll file another afresh, Malad, this may.
Another.
Oh. Let us do it. And
হয়েছে? ডাকো পরেরটা ডাকো। Next circuit, next circuit.
Malad.
Subject to its convenience.
নিয়ে নিচ্ছি, নিয়ে নাও।
হ্যাঁ ডাকো একটা।
Malad, with your kind leave, Malad, there's only one affidavit, so I'll make a copy and put it in the learned second data set.
Item number 14.
Special day.
Item number 14. Item number 50. And then hearing.
I am for the respondent.
Lordship, I'm for the appellant.
Yes, what is the matter about?
Lordship, this is an eviction suit against the order passed in an eviction suit.
Paper book?
Lordship, paper book shall be prepared within 2 weeks, Lordship. The TCR the notice of TCR, we have received it recently.
The paper book has not yet been prepared.
Placed for 2 weeks times.
ये टाइम फ्रे कुछ
Kojo. Appellant.
sir. কি বললাম তো স্যার? The paper book are not yet ready, despite there being a direction for preparing this same. It is submitted by the appellant that due to the delay in the trial court records reaching this court, the delay has occurred. Let this matter appear before the available let this matter go out of the list. The parties will be at liberty to mention before the circuit bench, then available once the paper books are made ready.
Grateful, Lordship.
চলো আর কি হবে অনেক কাজ করে ফেলেছি এই এত অ্যাডজানো না কনসেন্ট্রেশনটাই চলে যায়, ইচ্ছে করে না মামলা শুনতে ওরই অ্যাডশন মামলা হলে ঠিক আছে
Passport matter, item number 5. Passport matter, item number 5,
কবার হয়েছে?
the new file.
No, ঠিক আছে। No one appears in the second call. No one appears even at the second call. No adjournment is sought for. No one has applied to represent the appellant in the through virtual mode. The appeal and the connected application they give. কি আছে ওটা?
না শুধু সেকেন্ড আপিল।
The full stop the ইয়ে করেছে ডিফেক্টিভ থেকে কিওর করেছে the defect has also not been the defect as pointed out by the additional stamp reporter has also not been cured. The appeal full stop. This is a second appeal for admission. Full stop. The appeal is appeal. The appeal is not admitted. The appeal is dismissed for default. ধৈর্যের পরীক্ষা দিচ্ছিলাম তো এবার ধৈর্যের বাড়বে নিচ্ছে।
Item number 6, passover matter, under order 41, rule 11.
Yes, what are the judgments you want to show?
The last provision, I have find out,
What did you find out?
all are not,
All are against you.
honest. All are against me. Another thing, apart from law,
See.
dispute between mother and son, yesterday I told my client, honestly, but there is a stance of ambiguous better. The court and, for the child and.
For the timing, let the appeal be dismissed, then you settle it.
Settle. Who has prevented you to?
Take down.
Kindly, yesterday I told
See, you are not a very junior lawyer. You are putting quite some time. Reserve your energy for good cases. See, as an advocate, you cannot be choosy. Whether it is a unmeritorious or a meritorious case. Because we often find in unmeritorious cases, you get an order, and meritorious cases, you may not even succeed. So, you have appeared, you have tried your best. Now, let us dictate the order. The appeal.
It is a death of a heart patient at the hand of orthopedic surgeons. You are saying so that I am criminal practitioner.
Your lawsuit told over the adjournment lawyer. For this reason, I told my lord. My lord was only criminal. For this reason.
The appeal arises out of a judgment and decree dated 24th March 2025, passed by the learned additional district judge, First Track Court, Siliguri, entitled Appeal number 18 of 2023. Full stop. 23. Full stop. The First Appellate Court had set aside the judgment and decree dated 27th April 2023, passed by the learned civil judge, Junior Division, Siliguri, in title suit number 29 of 2017, by which the said suit was dismissed. Full stop. After hearing the appellate and considering the materials on record, we find that the appellant was found in an abandoned stage while he was a little baby. Full stop. The respondent had given care to the appellant as his mother, brought up the appellant, allowed to use the respondent and her husband, and brought up given care. তারপরে কি বললাম?
The respondent and her husband had given care to the appellant as his mother brought up the appellant.
As his parents, as his parents brought up the appellant, gave him education, as also got him married. Full stop. The appellant is about he is about 45 years of age at the present, as appears from the affidavit appended to the application. Full stop. The appellant was staying in the house of the respondent. Full stop. The respondent had asked the appellant to leave the said premises. Full stop. Subsequently, the respondent filed the title suit as aforesaid for eviction of the appellant. Full stop. The suit was dismissed on the ground that principally on the ground that no notice asking the appellant to quit and vacate the suit property had been issued. Full stop. On a perusal, on a conjoint reading of the decree passed by the trial court and the first appellate court, we find that the first appellate court has taken note of all the facts and have elaborately discussed the issues which were framed by the trial. The first appellate court has given reasons after considering the relevant provisions of law and thereby has decreed the suit by setting aside the the judgment and decree of the learned trial court by which the suit was dismissed. We do not find any infirmity in the order impugned. Moreover, the order is based on appreciation of, moreover, the impugned judgment and order is, judgment and decree is based on proper appreciation of evidence and the documents relied upon. The appellant has not been able to demonstrate any substantial question of law for which the aforesaid appeal is required to be admitted. The main thrust of the appellant is based on factual matrix, which has been duly appreciated and dealt with by the first appellate. In the aforesaid facts and circumstances, we are not inclined to admit the appeal along with the connected application, therefore stands dismissed. ওইখানে যেখানে বললাম না as dealt with the issues framed by the ওখানে একটা including the issue of non-service of notice as urged by the appellant.
Transfer matter item number 7 under order 41 rule 11.
ওই আগের যে অর্ডারটা হলো না ডিসমিসালের, হ্যাঁ ঠিক আছে, নতুন ফাইলিং হোক, পুরোনো ফাইলিং হোক, সেকেন্ড কলও কেউ নেই।
Item number 8 under review that I wanted to receive the degree or copy degree. Also, can you take from Wednesday? I have also mentioned this matter before the court below to supply the copy as early as possible. So instruction has also been sent to the concerned department to the court.
So how did you prepare the appeal without the degree?
When the judgment has been at that moment, I judgment.
Under the Code of Civil Procedure, as also in view of the judgments, the last two paragraphs of the judgment are to be considered as the degree. Let us look into it. No difficulty. What does the degree, the judgment, the reasons are given in the judgment.
What is the defect? Okay, given and taking that as and when you will get.
In the time of passing the degree was not there on the circular, the circular was not there.
কিরকম হয় বলো তো, এই যে ট্রায়াল কোর্ট কি করে একই দিনে, তো এটা তো আর সেন্টেন্স নয় যে পরে অন্য দিন দেয়, ডিগ্রিটা তো সঙ্গে অ্যাটাচ থাকে।
না, লোক নেই ডিগ্রি ডিপার্টমেন্টে, স্টাফ নেই, শিখছেও না।
Ordered in the, we follow the format under the civil rules and order, judgment, then ordered, that is the degree portion, that is required to be drawn up. But the contents of the decree is available in the judgment. Look at, and that is what our High Court, Supreme Court has said, and it is not regarded. The Code of Civil Procedure is clear enough. No, you, benefit is something different.
This
He-
partition should.
You have already filed it. The delay has got arrested the day when you file it. So,
Valuation is to be assessed.
পার্টিশন সুটে তো কালেক্টরের কাছে যাবে, ও জীবনে ডিগ্রি ড্র আপ হবে না। টাকা না জমা দিলে কে ডিগ্রি
You have challenged preliminary degree. That after final degree it would be. done.
হ্যাঁ no no preliminary degree then very
ওই যে ইয়েরা কেস করে দিয়েছে না ওই প্রমোশন পাবে বলে ওই জন্য তো রিক্রুটমেন্ট বন্ধ হয়ে গেছে।
আরে শোনো, সকালবেলা একটা সার্টিফাইড কপি দিয়েছে সিঙ্গেল বেঞ্চে, ডেট গুলো পর্যন্ত পড়া যাচ্ছে না। আমি তো পড়তেই পারছি না, উকিল বাবুও পড়তে পারছেন না। কি অবস্থা, মানে তুমি দেখলে তোমার কাছে দেখাচ্ছি, এটা মানে সার্টিফাইড কপি কিন্তু এমন অবস্থা, ডেট হচ্ছে।
Acute
See,
scarcity of staff.
no,
There is a problem regarding their promotion and such and
see,
such.
two things, Mr. Rai, not only scarcity of fund. You go to any district court, you will find that the stationery and other expenses has remained unliquidated for years together. And my learned brother has a direct experience of it.
No such fund. We have to approach the PWD such and such even for change of one bulb. It is
And unfortunate part is that we come to learn as a judge in charge of a district that at times the learned magistrate or the judge has to purchase stationery from his or her own.
I heard someone.
What can be done? See, the constitutional.
Budgetary allocation for this.
See, the constitutional framework is such that we judiciary do not have the financial independence. So we are dependent.
Executives.
And this is the end of the matter.
Judiciary is not supreme hearing. That I have some experience in high courts who are looking after the judges on bail. They are saying, is the king. So one person told me, I can check everything. It's
Not a, see,
But
the,
if you go to your Siliguri court, Siliguri, no building, nothing.
বন্ধ করে দিতে হবে।
That's it. You go to.
Lordship, several occasions I served the respondent, but it could not be effect, Lordship.
Anyway.
Finally, Lordship, direction the paper publication, Lordship.
Why? What is the affidavit of service? You have filed affidavit of service. Where is the affidavit of
No,
service?
Lordship, I have no copy have affidavit of service, all documents with him, Lordship.
With whom?
Advocate on record, he is a senior, Lordship, Ramcharan State.
Yes, now you are, what is your purpose to get an adjournment? Do you know what is the matter about?
He said that he sent me all documents, Lordship.
Oh. Delay of 2,905 days. There is a delay. Where is the affidavit of service?
Name.
Did you send the summon
Yes, Lordship.
the application at the proper address?
Yes, Lordship.
Then the question of substitution service will come.
He will set the.
So show us that you send the application at the
What is
proper
the,
address.
what is the presumption? Have you checked the provisions of General Process Act 1887? What is the presumption? Presumption is that if you had sent some article correctly addressed, properly stamped, and that article has not come back undelivered, it is presumed to have been served. Has the documents come back to you? Undelivered letters?
Lordship, all documents with him, Lordship. Early next week, Lordship, I have got.
Everyone is calling for next week. Next week is the last week for the circuit.
Nojrul Saroni Hakimpara, Siliguri, Darjeeling. You show that you in this address
ওর কাছে কোনো কাগজই নেই তো, সবই রামচন্দ্র দাসের কাছে আছে। রামচন্দ্র গুছাই।
Oh, you the state have challenged the order passed under section 18 of the Land Acquisition Act. Land Acquisition Act, 18 of the challenge. State is appearing for the state of West Bengal. So they made an application before you, before the collector. And in that application, the address would be recorded.
আরে অ্যাড্রেস যদি না থাকে তাহলে অ্যাওয়ার্ডটা দেবে কাকে?
You do not know the address. You issued 12-2, 9-3 and 4. Oh,
next সার্কিট সোমবার রাখি, দেখি কি হয়।
Monday.
I will dismiss it.
Tuesday, Lordship.
Tuesday will dismiss it. No, Tuesday, see, I don't forget, normally forget the matter and the face. Tuesday, it will be dismissed.
Yes.
Passover matter, item number 14, under tribunal motion. Item number 14.
ওখানে তো কেউ আসেনি।
এটা কবার ডাকা হয়েছে? ওই অর্ডারটা হবে ডিসমিস ফর ডিফল্ট।
আবার সাবমিট করে দিয়েছে।
Item number 16.
আর গভর্নমেন্টও তো আসছে না, মুশকিলটা তো গভর্নমেন্টও তো নেই।
Lordship, I'm on behalf of the petitioner.
Item number
Yes.
16.
16. Hearing seated.
Yes, what is the matter about?
Lordship, in this matter, Mr. Chaudhary is appearing. And he also mentioned before your lordships that he will be out of station for some personal difficulties in this week. And lordship,
Which Mr. Choudhury?
Jayjit.
Learned AG, Lordship.
Yeah, Monday.
Monday, Lordship.
Very good.
Great.
Item number 17. Lordship, I was supposed to do this paper for the last occasion. The intention was very bona fide on part of my colleague, my lord, a little because of some droplets of water, the original was like a little illegible.
You were appearing through virtual
Virtual.
from the last.
I am for the
Yes.
respondent.
You received the paper book?
Yes, received the paper books, but so far
No,
my
but.
lord, memory is recalled that there is no will actually. And the my lordship
Oh.
has been directed me whether you get the certificate, copy of the will. And I asked my client produce that thing and
They have produced. They have produced, they have handed over.
that is will.
So you handed over him, he will file supplementary affidavit?
Lordship.
Uh,
Kindly have. Kindly or-
You do one thing, supplementary affidavit.
Another.
No, no, supplementary affidavit, the supplementary paper book হবে।
Supplementary paper, affidavit.
বা additional paper book যাই হোক, আর ওই ইয়েটা originalটাকে ওই call for করতে হবে।
Original is lying, I think. So far my knowledge, my lord.
এই এটা তোমরা খোঁজ করেছিলে originalটা কি
Box,
অবস্থা?
there is a box has already been produced.
Oh, yes, absolutely. My lord, I have inquired with the department, my lord. So I was shown a photocopy of the will,
Yes,
and
sir.
as per procedure, they could not give me a photocopy from the photocopy, and that is the very reason I could not annex that in my paper.
So far as the original is concerned, that is
That should be
also be produced
should
because
be-
of the,
Ah.
in earlier case, I have got the.
করে দিই একটা ইয়ে, ওই ইনফর্মাল পেপার বুক করে দিন।
But it is our copy, you have to get it copied and hand over to us.
My lord, I can only get a copy from the respondent.
এটার মধ্যে উইলটা আছে।
No, no, we are giving him, he has handed over to it to the court. You take it, get it copied,
Yes, my lord, right away. I'm doing.
and hand over it to the court.
Yes, as you
On the next,
এটা কি ফাইল করলো পেপার বুক?
paper book agent.
Paper books.
The original paper book filed in court today is taken on record. Stop. The appellant says that the will in question, appellant says that a copy of the will in question is not with the appellant. Full stop. Respondent or respondents?
Respondents. All.
The respondents produce a copy of the will, which is made over to the learned advocate for the appellant. The learned advocate for the appellant shall prepare an informal paper book, including the will, the copy of the will annexed, included therein. Within
1 week is sufficient.
1 week to the circuit will expire only.
No, next subject is, and
I can get it within this week, my lord, that's not a problem.
again, you will come and ask for an urgent.
I will not ask for any adjournment, my lord. I was only traveling that day, and that way I lost my flight.
Within a course, within 10 days from date. Post of. We also find that in a sealed envelope, the original will is with the record. Or original will is said to be with the record. Post of.
My lord, did I state that? I mean, I did not state. I have not had a look of the original will yet till date.
it is direction of the court.
Acha.
It is the court direction.
You also find that in a sealed envelope, the original will is said to be with the record.
No, it's said to be there. কি বললাম
We also find that in a sealed envelope, the original will
the original will said to be in a sealed envelope is
Line with the
record.
আবার চেক করে নিয়ে আবার সিল করতে দিয়েছে তো ঠিক হ্যাঁ রিপোর্টও আছে হ্যাঁ হ্যাঁ ঠিক আছে এটা ওর দায়িত্ব হ্যাঁ
The original will contain shall be of the present returned to the safe custody of the register of the circuit bench for being produced at the time of hearing of the matter.
One more ingredient.
এইটাকে পাঠিয়ে দেবে রেজিস্ট্রার সাহেবের কাছে, কেন এটা যদি গোলমাল হয়ে যায় তখন মামলা নিয়ে আমাদের থেকে তোমাদের মাথা খারাপ হয়ে যাবে বেশি।
খুলে নিয়ে রেজিস্ট্রার পাঠিয়ে দিই রেজিস্ট্রার দেখবেন আপনার কাছে এইটা চাইবে অর্ডারটা চাইবে এই অর্ডারে একটা কপি দিয়ে দেবে সাইন কপি নো কেন ও আপনি আবার আপনাকে মাথা লাগাতে হবে না, আপনি শুধু উইলটা একটা সেফ কাস্টডিতে রাখবেন।
শোনো টিসিআর
In our code, there is the content number.
তো তোমাদের সমস্যাটা হচ্ছে তোমরা তো প্রসিডিওরটা জানো না বলে এটা বলছো, তোমার বুঝিয়ে দিই। ডিস্ট্রিক্ট কোর্টে তোমার হচ্ছে টিসিআর এর সঙ্গে উইলটা থাকে না, উইলটা এক্সিবিট হয়ে গেলে সেফ কাস্টডিতে চলে যায়। তো তোমার টিসিআর এলেও অনেক ক্ষেত্রে উইল আসে না, উইলটাকে অর্ডার করে প্রডিউস করাতে হবে। হাইকোর্টে যখন হয় তখন হাইকোর্টের অ্যাপ্লিকেশনের সঙ্গেই অরিজিনাল উইলটা হচ্ছে গেঁথে দিতে হয়, ঠিক আছে? তো এই টিসিআর এসছে মানে যে উইল আসবে এরকম ভাববা না, এটা হয়তো টিসিআর এর সঙ্গে এসছে, অন্য অনেক মামলায় দেখবে টিসিআর এর সঙ্গে আসেন।
One ingredient, the paper books, I didn't find a cross of the chief of the witnesses, chief of their evidence. So kindly, that can be incorporated.
If I may be allowed, my lord, there are a little infirmities which I would have like to bring into the notice of your lordships.
সাপ্লিমেন্টারি
No, my lord.
Informal including the will though.
My lord, page number 18, there is the chief is there.
Chief or cross, on cross.
I was never allowed to cross, my lord. It was written closed being ex parte, whereas in that order it is written that it is on pass
Very
on
well.
contest, my lord. And a lot of infirmities are there.
No,
Very well. The appeal may be placed before the next circuit bench, subject to its convenience.
নেক্সট অ্যাভেলেবল আছে 10 দিন
হ্যাঁ।
টাইম দেওয়া হবে।
নেক্সট অ্যাভেলেবল 10 দিনের মধ্যে হবে না, তো পরেরটা বলে 30 তারিখ থেকে, ওই জন্যই 10 দিন দিয়েছি।
ওকে নেক্সট
Much obliged.
Item number 18. Item number 18.
18, I am for the respondent, my lord. But I made a mistake today, my lord. I couldn't bring the brief, my lord. I included. Its contents, it have 4 volumes, my lord. I came with Mr. Thor, so it stayed in my car. It's a genuine mistake, my lord. Kindly takes it on Monday, my lord.
My lord, then I
I'm
will
ready with
pray
them.
for next Saturday, my lord. And I do agree, Mr. Pal
Do you
said,
know what is the present name of Mr. Dhar?
মিস্টার ধর
Demolition
ইয়েস
Dhar.
JCB দ্বারা
JCB though.
নো
Meghna,
মেঘনা
he is coming, vanishing, coming,
My
vanishing.
lord, Mr. Dhar is also under already a contempt emotion because he did not give birthday party.
Oh,
He was my chamber.
after receiving gift.
Meanwhile, he used to go.
তাহলে Mr. Roy
Then Mr. Roy will give. Even after receiving gift, he did not give the part.
I said, yes, sir, I see that please come. Came to my
Please don't.
But kindly fix it in Excel.
But what is the matter about?
My lord, actually, it is the arbitration, against that 3-4 was filed, rejected on the ground of delay. That is the-
Come next week to Monday.
Monday, my lord, Monday, your lordship had already asked me to get ready for 3 matters,
Yeah.
3 appeals.
You are already ready. So it is your submission or your admission that today you are appearing without being making yourself ready.
Lordship,
If you have to get yourself ready on Monday for this matter, then is it your submission to take judicial note that you are appearing today without being getting yourself ready for the
no, my
matter?
lord, your lordship knows residual retention. This is
It was a
residual
bouncer.
retention. It was a bouncer. This is the.
চারখানা করে পেপার
আরে কিচ্ছু নেই লিমিটেশনে 34 যদি লিমিটেশনে উড়ে গিয়ে থাকে ওটা করার কিছু নেই সেই পপুলার কনস্ট্রাকশন থেকে হচ্ছে ওটা সেটেল ওটা সেটেল
Well, that hurdle we have crossed much.
হ্যাঁ
At the time of. Yes, so, but my lord, keep it on Tuesday will be.
let us see at least some matters to
No, my lord,
be,
3 matters, your lordship has already.
to keep us engaged some matters
So, my lord, we'll do the 3 appeals, 3 matter appeals on Monday. And Mr. Vikramaditya Ghosh is for the respondent, and on Tuesday, my lord, if it, lordship keeps to it. I hope Mr. Patel will come with Mr. Thoran that day.
He will come with you or he might come.
No, don't miss the.
Usually I take his car on Fridays, my lord. So it
ভেরি ওয়েল নেক্সট
মঙ্গলবার রাখো শোনো হবে কিছুই ন অ্যাটলিস্ট আমাদের সান্ত্বনা থাকবে লিস্টে মামলা আছে
তুমি করো, তোমাকে ছেড়ে দিচ্ছি, তুমি বড় দাদা।
grateful.
Item number 19.
Lordship, in this matter, Mr. Abhishek Sarkar is appearing for the appellate. He could not come due to his wife's illness, Lordship. So I'm paying for now.
It is a genuine cause. Genuine cause.
not today
Special cause.
Item number 20.
I don't have husband. It's a matrimonial.
who is for the respondent
My lord. Yes, say the dates, man. I filed this petition for matrimonial suit for the round of petition on the ground of cruelty. Although in the petition I have not said cruelty is good.
এটা কি হিয়ারিং হচ্ছে আমাদের
Yes, yes. I do.
Can you complete it?
Oh.
3:30 আছে
And
ধরেও
it will take time, man.
আমি ধরেও কিছু আমরা করতে পারবো না
But I am ready, I can do it.
No, what
Your
is the
loss,
scope?
your loss, you know.
What is the scope? Because see, Mr. Rai,
They are earlier matter
I
I argued.
And then ultimately it could not be. I had to leave it.
It's
Your effort got wasted. My effort also got wasted.
Then can you take the Monday? The first I will say.
No, you can start if you
Yes.
want. What is the scope of the matter?
I said, what happened?
You filed a.
I filed a petition for divorce on the ground of basically, although not say the ground of cruelty.
Section 13. Section 13.
I said the dates. The marriage took place on 20th June 2002. The wife in the matrimonial house till 20th July 2003. Admittedly, she left 20th July 2003 while she was pregnant. Then 2003, he gave a birth to a female child. Myself and my in-laws of her went to the hospital. She did not come back. So my lord, on 28th June 2003, she was, admittedly, she was residing separately. After that, she filed two criminal petition. One, this is 406, other is section 498. Then 13 March 2008, I filed a suit for this application for divorce. The ground of cruelty because of pendency of the 490 application and 406, apart from 125. The learned judge held that yes, the case of the my husband was proved. Moreover, by the cross-examination of the wife, that was proved. But learned judge went to the other point that I did not take care of her, as in it is her petition, so I should not get the divorce. Now, what happened at the time of judgment, both the petitions 498 and 406, both are pending. Now, in both the cases, I have been acquitted. I mean, myself, not my brother, acquitted. I brought to the as additional evidence in this petition. But this is not settled, not the 498A. When I filed the additional evidence of the acquittal of 498A, my learned friend filed an appeal in that 498 acquittal before the district court, my lord, that is pending. Once they file, that is withdrawn, again file is now going on. But against the judgment of 406, they did not prefer an appeal. But this is a stage. Now, apart from Shomargor's judgment, there's a Supreme Court says in a 498 petition, it is an acquittal. Because I have to face the trial, it amounts to
Cruelty.
This is my matter.
Only 406.
No, there are two other.
498 appeal pending.
But this is not the ground. What Supreme Court says, whether this is an appeal pending or not, but I have to face the trial. Then this is a mental agony. Now that I can cover by judgment. I just brought all judgments, my lord. And Shomargor's also or that judgment, Shomargor's that is decided all 11 points. But can you see for 2002 marriage, 2003, this is admitted, right? She admitted that yes, I left the matrimonial house in 2003.
What is your client doing?
She's a primary school teacher. She will retire on 2006.
Retired?
No, he will retire 2016.
Wife is a working lady?
She's a para teacher. I admit, I'm not saying anymore. My laws don't, right? Not anything. Para teacher. Now, I suppose she's getting 13,000. I'm paying the maintenance of 6,000, 12,000 of the revision, 6,000. There's some pending that I paid now. But by this time, daughter also.
What about the minor daughter?
Now she become major.
2003.
Female child.
But on 498, but
Not married as yet. Has not married as yet.
No.
Female child.
Dependency
Still there.
She had daughter and son always different, according to me. That is our Indian customs. So I'm taking money.
You settle the matter.
Well, this is
Actually, they are living separately since 2003. 22 years.
Disaster account is also there, but that was not taken.
See, Mr. Rai, the difficulty is that I was telling that day whether you were there or not. I lost a matter before the division bench of Justice Indira Banerjee and Justice Subroto Talwalkar. In fact, the two counsels for the sides have subsequently got elevated. Justice Sombhusachi Bhattacharya was on behalf of the wife, and I was on behalf of the husband. The Supreme Court has evolved a procedure, but that is under 140.
No, that's not.
The difficulty is that that is how I got axed over there, because I relied upon the judgment of Justice Ruma Pal, sitting in Supreme Court, and Justice Ranjana Desai, which has been followed subsequently also, that two elderly couples, if they are in a situation of beyond reconciliation, then it is better to give the decree for divorce.
Yes, that is one bill 490. Now I am covered 498 is acquittal. It's a amount to cruelty. Only
Yes,
one my
what is
matter.
your instruction? What do you say?
My lord, there is some amount is pending from their end, my lord.
No.
In
That I
maintenance,
That I pay.
almost 2 lakhs amount, almost 2 lakhs, my lord.
That I pay. Then I even take instruction.
Primary teachers are now retiring at age of 65.
No,
60.
He paid, my lord. My lord, he paid just example, my lord. He paid month of June, next month of August, next month
No,
of.
if you can sit across, then we can think of a permanent alimony.
Yes.
My lord.
And then we will be more interested in protecting the interest of the daughter.
My lord.
You cannot also shirk your responsibility, the father cannot.
No.
So you are also a para teacher, he may be a primary school teacher.
Private teacher, I was on the verge of retirement. I lost my parents. But this really, some higher subject, there was an ego problem. Irrespective of status, ego problem is the main thing.
Mr. Rai, now in the present socio-economic condition, this is one of the greatest problems. See, no one has any allegation. Previously, there may be an allegation. The wife is highly qualified. She is getting married at a considerable age, has her own fixed values. Now that value and views cannot be changed. But at the same time, she is coming from one house to the other house. Now the husband, he has his own values, he
Yes.
has his own views. Conflict of views, conflicts. No one has anything against the other, but they cannot jail together.
Because their own views, strict own views. I don't know.
Now I was reading an article that day. In West, this has been connoted as a silent divorce. Silent divorce. Staying together, but no one knows what the other is doing. You sit in the dining table, have your food.
Yes. Both are busy, both with computer, laptop. So
This is silent divorce.
in my family, I'm seeing everything.
See, the vices of the Western society has ultimately percolated.
Yes. In our society also, and we're taking it otherwise.
Previously, the concept of the undivided family, where the relatives were involved, seniors were involved in reconciliation.
Values, there's some values.
Now the families are nuclear families.
Yes.
No one will take the pain of even coming for to assist in reconciliation. No one, because they are so independent, can't help it.
No, I'm also sorry to say, the shoot for 2008, it continues up to 2023. This is one. It should take at least one hearing is enough. But now,
What is your instruction? Does your client is really interested to continue the relationship?
It's not possible.
No,
After 22 years.
possible.
Yes?
No, Lordship.
And persuade them, sit with Mr. Bragg, persuade them to
Hello.
come to at least at the old age, let them live in peace.
The court, it's a court, evident. My, the losses know that, you also know that one of my uncles and the Rebara and that Manimishra, my own uncle, Dr. Roy, after 20 years of marriage, they filed a divorce. My sisters, they are all settled. One is IS officer. After 20 years of marriage, all the ego problem. Aunties don't want so much educated. Sons, engineers, sister, daughter, highly qualified. Father is a doctor. Only this is.
So you, Mr. Roy, you think about certain permanent alimony
Your
for
Lordship,
the,
can you consider?
for the daughter as well as
Can
for
you
the.
consider my position also? I'm a private teacher. But I'm getting my salary 68,000. Now I took everything. My pension, my parents are there. They died. So my condition is not very rich like a businessman.
If your daughter cannot get
That
any
divorce,
job
daughter,
or source of livelihood.
in respect of erasing my poverty, I
Yes,
should. That I
yes,
also,
you have to make arrangement for her marriage. You consider,
I talked
and
to
there
my-
be no such incident. In that circumstances, you are under the
I
liability
talked-
to.
It was absolutely. I talked to my client. He
Yes.
said she was not allowed my daughter to meet. This is really said. Although irritable background is not a legislative that my lord said Supreme Court's view. But 498, both the cases I got that to tell. Not only myself.
What your daughter is doing now?
He's a BCA honors study.
Pursuing,
Pursuing BCA honors and
She's a
almost
commercial.
30,000 is semester fees.
She's also commercial artist. It's hard to see the commercial artist.
30,000 for semester fees. In semester, 30,000.
I know.
Me to continue
See,
the.
See, the difficulty is that if you want a settlement, we shall not be hearing all these things because the next, if you go to your client, the first thing will be that for so many years I have been taking care of my daughter. Where was the father all these days? So if you enter into all these problems, or all these issues, there will be no, see, law will take its own course. Mr. Rai's client may get the decree or by getting it set aside or something like that, or you will ultimately, what will be the benefit? Because think today one is about 60 years, your client must be about
52.
So 52 has to see the
52.
52.
So most probably there is no possibility of reunion. Huh? You have a talk with your client. Even if for the sake of argument she succeeds in this appeal, then also he is also not in a mood to reunite with her husband. So what would be the fate?
Now I'm in a good level.
The appeal arises, the appeal arises out of a rejection of appeal arises out of a judgment and order dated
12th September 2020.
12th September 2020. 12th September 2023 passed by the learned district judge, by the learned additional district judge, second court Siliguri, in matrimonial suit number 30 of 36 of 2008, by which the appellants apostrophe S suit for dissolution of marriage filed under section 13 of the Hindu Marriage Act. 55, Hindu Marriage Act 19 was dismissed. Full stop.
Refused to.
It appears that it was dismissed. It appears that the appellant is aged about 59 years and is scheduled to retire in the next year. The appellant is a primary school teacher. So the respondent, bracket a wife, is a para teacher. The couple has been residing separately since
20th July 2003.
Since 20th
July 2003.
2003. The daughter, who is aged about 23, who is aged about 22 years, is residing with the respondent, is residing with her mother, the respondent. The respondent is aged about 52 years. We feel that even if the appeal is decided either in favor of the husband or in favor of the wife, no fruitful purpose will be served as reunion of the couple is a mere impossibility, as appears from the submissions made on their behalf. We therefore think that the respective advocates should talk to their clients and the advocates should talk to their respective clients and also exchange dialogue, inter se, to find out if any if any workable solution and or settlement can be arrived at between the parties.
It's very difficult.
Let this matter be placed before the first available circuit in the month of August 2025. কটা বাজে? 3:30 বেজে গেছে? ডাকো আরেকটা ডাকো।
Item number 21.
ওভার ডাকা হয়েছে। হিয়ারিং ম্যাটার ডিসমিস করেও লাভ।
Item number 22.
I'm not ready. But by Sunday, I'll make my solution. Then you have to know, I'm very
Who is your other side? You have to bring your other side. Give information.
When I moved to stay also, they did not turn up.
Oh.
For department, they have some.
The difficulty will be that you will get yourself ready, but we will not be ready to take up the appeal.
Yes.
Because
I'm sorry. It was Mr. Last French Justice Panta said, Mr. You always prepared. Now you're not prepared. No, no, it's all. I'm moving in the boat. It take much more. It's on me.
now you are getting a new train.
Yes. But the
But-
time schedule will be help us.
Yeah, I was looking into, it is a very good timing for departure and arrival. But the intermittent stations, there they will be having, it is 11:30 from Jalpaiguri Road. And it will reach at 12 o'clock at Shialda next day. Similarly, 11:30 from there and 12 o'clock at. So
I might have one day.
Hmm. One night.
But it's good for one doesn't, but I actually, I pant, pant beef, sit and started to work.
no, but
It's big, but
they are giving only AC 3-tier coaches. No, AC 3-tier coaches. 23 or 22 AC 3-tier coaches and 2 sleeper coaches. And the difficulty will be that, see, I tell you, it will 11:30. It will reach at 1 o'clock at Krishnanagar. The people who will be benefited for the timing, they cannot take the benefit. Barampur Court, it will be around 2:30.
Good for us. But it is very much.
Best timing was Kanchan Konna. At one point of time, I used to come regularly to Islampur, the court. Kanchan Konna was 7:25. It used to depart early morning over
Morning
there.
at 6 o'clock.
Aluabadi station. Let us go see what is the response. Dakota.
Item number 23. 23,
What is the matter about?
Matrimonial court in the respondents husband respondent wife petition. And appellate and the separation will be as well. That is, they have been separation from 27 August.
Who is your other side?
Other side has not been received the copy, but will appear. And in page number 160, where the notice we should have responded. Notice has been issued from the court. They have India, yeah.
Not today.
From the court. Court will take responsibility.
No,
Sir.
No. Here, there is the notice we issued to the respondent.
Administrative notice. Now court is to take the responsibility to bring.
I given the tribunal.
Oh.
At the time of.
Okay.
বেঁচে আছে তো তাই দেখো।
Individual, I can have it motive
Very well.
more myself. That is
After all, it is a just certificate.
You are trial court advocate. Contact the trial court advocate.
Don't the Bhaskar man, yes. Just আপনি দেখেছি সবাই। Intimacy. Did this? I have given order. I don't want to.
So really in our high court, no, we have seen.
এখন ওই রকমই হবে ভুলভাল কেস নিয়ে নিয়ে তো বলো মাইলর
Huh? Wednesday, Wednesday, Wednesday.
Wednesday, come on Wednesday, yes.
Dapo, Dapo.
Mandamus appeal hearing. Item number 24.
My lord, I'm appearing for the petitioner. The matter is a very short matter, in fact, my lord. If lordship sees here.
But today, because of the resolution, our time is also very short.
My lord, may I request, your lordship may take it up on Monday, then I will come physically. For Monday and Tuesday, I will be visiting. So lordship, if kindly takes it up on Monday.
See, it will be in the list on Monday. We cannot assure you because if an appeal before your matter is taken up and it continues for hearing, we cannot. But as it is, you are coming. It is not that you are coming.
No, I will come for this. I will come for this matter. I will then come for this matter only, my lord. Because this is a hearing matter, and since your lordship is hearing, hearings are not being taken up. So since your lordship is taking up hearings, my lord, I will come up. I will come for this only. Because this will not take much time, 15 minutes maximum.
Why?
Because, my lord, here it's only a question of show cause notice. Second time, show cause has not been given. A very short issue, very short issue.
Very well, not today. Let us.
If lordship kindly favors me with Mondays any time.
See, we are reluctant in fixing any time because we do not know what will be the fate of the list. If it collapses, you won't be there. So
I will be there. I will be there from the morning that I can.
If you come on Monday, then you come and mention, we will try to. If it is possible, we will try.
Grateful, grateful.
On Monday, we have several matters. Everybody is asking for Monday. Maybe it is an auspicious day.
My lord, my lord. Very well, lordship. Then I will come on Monday and mention. If lordship says so.
সিভিল অ্যাপিল গুলোর হিয়ারিং কেউ করছে না দেখো ম্যান্ডামাস গুলোকে যদি আপুকে তুলে কিছু করা যেতে পারে দেখ কথা বলো
Grateful, grateful, my lord. Grateful.